Sir.
Let's see, Mr. Smith. Looks like you got, these are old, back in December of 2013. You had no valid inspection certificate, operating with expired plate, driving with an invalid license, and no insurance second. If you want to plead not guilty to those, you can. I can set a bond in these cases. You can also plead guilty or no contest, and you would be time served on all of them, so you'd be done with them. What are you wanting to do?
I was guilty of that back in 2013. You just left my attention. I own the Paladura zip line out at the entrance of Paladura Canyon.
Oh, right, yeah.
I build zip lines all over the country now, and the Chinese have approached me about building zip lines there as well. So I probably have 10 to 15 vehicles in my possession at all times, and so when I'm slipped past me, then I have people that kind of keep up with that, and that one slipped past me. So
sure. Well, I will, on your plea of guilty to those, I will find you guilty. I will time serve you. Looks like you've got some other things going on as well. So good luck to you, sir.
Thank you, sir.
All right, thank you.
Welcome back to Time Served, the channel that scans the docket so you don't have to. And potato, potato, tomato, tomato. It's all the same according to Judge Bryant, as she teaches this gentleman how to curb his anger. Then she has another gentleman who doesn't know how to use Zoom. Then in Georgia, there's a child abandonment case where this gentleman has 10 kids. And this baby mama has 3 of them. And apparently, since the woman is doing good financially, why should he have to pay for those 3? You'll see that one. Then we go all the way down to Florida in Bay County, and then we visit Judge Vann. Don't talk about your case. All that and more on today's docket. Make sure to hit that like and subscribe. Set your notifications to all. Court is now in session. Let's roll, nerds.
Your Honor, I had an opportunity to speak to Mr. Dye earlier. I believe this matter is for failure to appear. He was also held on a non-support bond. I know that he will be released on that. In this matter, I'm requesting a personal bond. Mr. Dye tells me he missed court because his phone was broken. He wasn't able to get on Zoom. He tells me he'll get a new phone and contact the court. I know he's been working with CMH, and he needs to contact probation to get proof to them of that. I know he drug tested as recently as August 11th. He's fully employed now at the Dollar Tree. I'm just asking for a personal bond so he can continue compliance with probation.
Well, there are a couple of concerns in what you said. Mr. Burton, this is not your case. There are a couple concerns in what you said, Mr. Green. The first one being that he could come into the courthouse at any point in time. He doesn't have to get on Zoom, and he did not do that. The second one is he can't continue to be compliant with probation because he was already in violation of probation. That was the reason why he was supposed to be here in person when he failed to show in the first place. So he has had, since this case began, we count the number of warrants he's had. All right, he had one in March of 2023. That's one. Then he had one in July of 2023. That's 2. And this is his 3rd bench warrant since March of 2023. So something is going on with Mr. Dye at this point. Mr. Dye was in the Hagira treatment program for a while.
Mr. Dye, are you still doing that treatment
Yes.
and you're working with CMH?
Yeah, I'm still working with CMH. I just got a job to working at Dollar Tree. I'm just not getting paid, so I can pay my child support, and I can take care of everything else. Only thing is that I'm really ignorant when it comes to how the courts move and how to deal with finding stuff on the computers and stuff like that. But I'm trying to be in compliance with everything that I have to do. I have a court date on the 7th, and I'm trying to meet everything, and my phone got broken. I messed up.
And Mr. Dye, do you know how to enroll in the MRT program?
No, but I don't know how. What do I go about doing that MRT program?
So you need to talk to your probation agent about that. She can get your referral back over to the MRT program so you can get enrolled and give you directions on how to do that. When this matter was set on August 17th, when I issued the bond, I did a no bond in this case. So do you have any proof that your client is still in Higera program?
That's the first I heard of it, Your Honor. I know that Mr. Dye has proof he's been engaged with CMH, and I know that he went to his drug test on August 11th. As to that treatment program, that's the first I heard of it, Your Honor.
It's the first I heard of it too. So
It's the first you heard of the Higera program?
yes. The only thing, the last judge I talked to, they told me to go drop on the 11th. I went and dropped on the 11th. They said I had a court date on the 18th. They said my court date for the 18th. My phone was the charger port was broken on the 17th. I was trying to charge my phone. I had court on the 9th. I was trying to look for a ride to get something, like trying to figure it out, but I couldn't figure it out. So the only thing I could do was wait until I got paid on Friday to buy a new phone so that I can figure everything else out, because wasn't nobody really helping me. I got to figure it out myself.
How'd you get picked up, sir?
I went to my probation hearing in Ann Arbor for my other court in the 15th district, and so in the process of me taking care of that, I was letting them know that I have these warrants and I don't know what to do with that. And then she took me downstairs to the police department and said they was come handle it. And then they brought me over here, and I've been waiting.
So I'm surprised to hear that this is the first time you've heard of the Higera program, because it says right here, I got a letter. Can you take me off?
360-359-6659.
Thank you. Mr. Peck, is there a stipulation of probable cause today?
Correct, Your Honor. We'll stipulate to probable cause for this arraignment only.
Thank you. Notice stipulation of probable cause and a charge of assault domestic violence. Enter a not guilty plea for Ms. Guzman Tucker to that charge. Ms. Guzman Tucker, how do you support yourself financially?
Well, I'm married, so
Okay.
my money
And
is just I have SSI on my own, but I use that
Okay.
as my husband's income, but I can survive without his income if I have to.
Okay. All right. I will appoint counsel to represent you. And that will be Ms. Langley.
So the city of Lacey box, are you the prosecutor or something? I'm just curious. I see city of
Yes,
Lacey.
yeah.
I only
That's a
see
fair
that when I
question.
get my water bill. That's why I'm just wondering.
He doesn't read your water meters.
I know, but that
He's
logo.
the prosecutor for the city of Lacey.
May I ask a question?
You may.
Because last night, one of the officers said I had a misdemeanor warrant on me, and I said, I don't know what you're talking about. And then today I heard that I'm in violation of an NCO. So is there somebody else that has the same name as me or something? Because I don't have. Sorry.
Yeah, I don't see any warrant outstanding. We're just
I
here
know
on this
I
one.
don't have anything.
one
I
charge.
wouldn't run if I had one, trust me.
Okay, good. All right, Mr. Sharp, city's position on release.
Thank you, Your Honor. Excuse me. No objection to a PR release. City is asking for law-abiding behavior that Ms. Guzman Tucker not possess any firearms or other dangerous weapons, that she surrender any firearm or concealed pistol license she may have in her possession or control, that she abide by the terms of domestic violence no contact order is presented that would protect her husband, Mr. Tucker.
All right, thank you. Mr. Peck?
Thank you, Your Honor. So defense will have to object to the current no contact order against the husband. And we acknowledge the situation and the escalated situation right now, and it does call for it. But the complicated issue right now is she is a homemaker and she lives at the home. The situation occurred at the home, but then she also needs to remain at the current residence that she's at. She's a caretaker for the grandson as well. And so she's
And my
asked the
granddaughter,
court,
my infant, well, she's a year and a half. Mom died after she was born, so I'm taking care of Atiana also.
okay. And so with that said, Your Honor, if we put a no contact order, I mean, she's going to be pretty much, unable to care for the children, and then also she'll be out on the streets. So we're asking the court if we could place at least maybe a no hostile contact order, or maybe request somehow, I don't know, ask the husband to find a place so that she can at least temporarily stay at the home until they can get their matter straightened out.
May
All
I
right,
say
thank you.
something? Am I allowed to speak? He was due to go on vacation anyways on August 26th if he goes through, but I did ask several times, could you please be a man, just in the heat of escalation arguing, could you please just go get a room and go to work in the morning from there? And he was adamantly, no, you leave, it's in my house, blah, blah, blah. But maybe we just need some space apart, because I don't want, my granddaughter already is lost enough, and I can't function very well in that kind of tension environment. I need a good person, but there's just some things going on that need to be settled.
All right, thank you, Ms. Guzman Tucker.
Sorry to have interrupted, but I do have some information that may help the court just as far as the nature of the allegation here.
Yeah, no, that's fine. I don't need that. All right, Ms. Guzman Tucker, I will authorize your release today on your own recognizance. I am going to order that you have no contact with Tommy Tucker Sr., your husband. And I understand the problems that creates, but I also understand some of the solution it creates as well, which is addressing what you just said, that two of you have space. Now, I can't direct him to leave the house, so I don't have the authority to do that.
Well,
what
if
I'm gonna
it's nice
do-
outside, I'll camp in the backyard. I have a tent. I'm
Well,
just joking.
yeah,
I just don't know how to do this.
Right. You're not going to be able to be there because you have to be 1,000 feet from the property. So what I'm going to do is, normally I would set this out for 1 month. In this case, I'm going to set it out for 2 weeks so that you and Ms. Langley can get together. And
So am I having to leave the house? I'm kind of confused when you're saying the no contact.
yes. Yeah, you may not go within 1,000 feet of the house. You can't have any contact with your husband. You can go to the house you can go to the house one time with law enforcement to obtain personal belongings.
What about my grandchildren?
Those aren't your personal belongings. So, if whoever is the guardian takes possession of them, that's fine. I don't know what the status of that is, but you can't go to that.
I'm the guardian.
home. Okay, you can't go to that home. There's no order as to the children, just an order as to Tommy Tucker. And I'll set this
So
on.
the kids could be brought to me.
Hold on.
I'm trying to understand this. Sorry.
We'll get back to you.
Okay.
So
sorry.
I understand that that's an issue, but my response to that is I'm going to issue the no contact order, but I'm going to set a quicker hearing so that you can work with Ms. Langley and see if two of you can propose a way of dealing with this. I don't know the situation well enough to be able to come up with something any different. So rather than making you wait a month, we'll get you back here in 2 weeks. And on the 28th of August, and that's actually less than 2 weeks, and see if you and Ms. Langley have a creative way of, you caring for the children. But between now and then, you're to have no contact with Mr. Tucker, can't go to the residence except with law enforcement one time to obtain some personal belongings.
But if he agrees to leave, will that change? If he's asked would he be willing to, then does that make it different? Or does it have to
Well,
come
the
from
problem
court?
is that's his residence. And if he just is temporarily gone, typically the
It's our
order still
residence.
remains in effect.
It's
Oh,
our
okay.
house.
Yeah, no, I understand that. It's yours as well. All right. I'm going to let you work all that through with Ms. Langley.
Oh.
So between
So
now and the
today when I'm
28th,
released, I cannot go there at all. My vehicle is in the garage.
like I said, you can go there one time. You'll have to contact law enforcement, and you can go there one time with law enforcement and obtain your personal belongings. But that's it. You can't go there without that.
And I can get my personal belongings, my vehicle, and my grandkids. If Dee wants to stay there, he's fine. He's 17, but Atiana is a year and a half.
Yeah, I'm not commenting on that.
Understood.
I'm just saying, okay, thank you.
Okay.
All right,
I
we'll see you
appreciate it.
on the Monday, the 28th
How
at
do I
10
get back
o'clock
to
in the morning.
Lacey?
I'm sorry?
How do I get home or get out of here? I don't have a vehicle.
Yeah,
Okay, I'll figure it out.
okay. Thank you, Ms. Guzman Tucker.
Thank you very much.
Yeah, bye-bye.
Bye-bye.
Next,
See, I mean, I'm trying to get in a hurry.
Credit.
I need to slow down and appreciate the last day of my duty cycle.
you do not. State your name.
Mr. Woodfall, sir.
Mr. Woodfall, you're for the court on a leaving the scene of an accident charge, driving license suspended revoked, fleeing and eluding, possession less than 20 grams of marijuana, possession of paraphernalia, resisting officer without violence, and failure to identify. You understand those charges?
Yes, sir.
I understand you've been given copies of paperwork and advised of your rights. Is that true?
Yes, sir.
Mr. Woodfall, based on your application, I find that you do qualify. I'm going to go ahead and appoint the public defender to represent you. So you have an attorney now. Any question about that?
No, sir.
Deputy, criminal history?
Last month, petty theft resisting, 18 resisting false ID, no valid criminal mischief, cocaine possession, 16 no valid FTA times 2 no valid. History is back to 12.
All right, 5,000 leaving the scene, 2,500 on the driving license suspended revoked, 25,000 on the fleeing, 2,500 on the pot less than 20, 1,000 on the paraphernalia, 2,500 on the resisting without, and 2,500 on the failure to identify. Court date's going to be September the 14th at 9 o'clock on the felony charges. On the resisting and failure to identify, the court date is August 28th at 1 o'clock. Good luck,
To your
sir.
right, to the T, 41.
How many felonies they gave
Miss
me?
Pam
I don't know.
Hey, excuse me, sir. How many felonies did they give me, Mr. Grumman?
Van.
Whoa,
Man,
whoa. Yeah.
I'm sorry, Mr. I get y'all mixed up. I'm sorry, Mr. Van. I'm sorry, Mr. Van. I'm sorry.
I'm twice Judge Grammer. I mean, that's
Yes,
not
sir. Yes, sir.
physically twice. Not.
Yes, sir.
I'm
Yes,
half
sir.
a Judge
Yes, sir.
Grammer, probably in other ways, but I'm twice physically of Judge Grammer.
Yes,
Judge
sir.
Grammer, Judge Grammer couldn't even fit up with me.
But no, what I was gonna see was, okay, how many felonies did they give me?
Okay, the fleeing and eluding is the felony.
Okay, and the rest of them are misdemeanors?
Yeah, they loaded the boat.
Down where the light is. Next,
Miss Fambro.
sir.
Mr. Rochelle, how you doing, sir?
All right.
Good. Before the court charges fleeing and looting, use of a two-way communication device during the commission of a felony, aggravated assault with intent to commit a felony, and a violation of probation for manufacture crack cocaine and felon possession of ammunition. The Shepherd's here on your behalf. Mr. Shepherd.
Who?
Your attorney for today. Maybe not for long.
Rusty Shepherd, I'm here for you.
Rusty Shepherd? That's him?
No, he in the courtroom.
Oh,
You can't see him.
okay.
JP, was you? Who?
All right, Marius, this is Rusty Shepherd. I'm here in the courtroom with Judge Vann. You can't see me, but I'm here.
Sneaky.
Yeah.
Yes, sir. I hear you.
Your Honor, Mr. Rochelle, as a police client, has always appeared and been very amenable to whatever the court orders. So we are requesting that you give him a bond in this case.
I'm gonna give him 3. Problems that fourth one. The problems that going 3 for 4 will get you in the Hall of Fame, Rusty.
No, Judge, we need it all 4.
Yeah, I know. Well, he's gonna get credit. Let's put it that way. On the fleeing and eluding bonds, $15,000. The two-way communication device is $5,000. The aggravated assault with intent to commit a felony is $15,000. He's held without bond on the VOP. His court date's gonna be September the 28th, 9 o'clock. Good luck, sir.
Marius, we'll be to see you and we'll address the holdout, okay? Thank you, Judge.
Thank you.
Hold on, because I think there's another one that you might want to do, so he gets credit for the other one.
What's the other one?
Oh, you can check it. It's 2745 CT.
What's that?
Was he out on bond or something?
It shows the probation, but that's what I'm saying. Check it because I'm not finding the.
What's that case number again?
2745 CT. He can hear you. He's not muted.
Probation.
27:45. So they coming at 2. You know.
They'll give him that. They'll tell him.
Marius, I think we talked to them on the phone to let them know that this was when it was.
Oh, okay.
Yeah.
Yeah.
Marius, you got another case that's out there, and I think the judge is going to hold you without so that you're clicking time on that one too.
I don't have enough.
You're on probation in a misdemeanor traffic case.
Oh yeah, that's
It's no big deal.
Yes, sir.
I mean, it's of all the things you got to worry about, it's the least of your worries. But I'm gonna make sure you get credit on that one also. Yeah. Good luck.
Red X. State your name.
Kimberly Dobson.
This is Ms. McCall?
Yeah, it's Dotson, but yes, sir. That's
Okay.
my,
You're for the court charge of possession of meth, possession of paraphernalia, and tampering with evidence. You understand those charges?
yes, sir.
I understand you've been given copies of paperwork and advised of your rights. Is that true?
Yes, sir.
Okay. Based on your application, finds you do qualify for the services of the Public Defender's Office. I'm going to go ahead and appoint the Public Defender to represent you. Any question about that?
Okay, thank you. Yes, sir.
Deputy Criminal History?
18 trafficking over 14 amphetamine, heroin with intent, paraphernalia, possession of a new legend drug, controlled substance, synthetic with intent. 17 meth with intent, paraphernalia, DWLSR, VOPs through 18. Locally, it goes back to 9.
Oh. Ma'am, I just want you to know your son's present in the courtroom and he is, well, he's disappointed.
If I could speak, sir, I did not have anything on me. They found a white vial in the center console, and it was a
Don't
marijuana.
talk about it. Wait and talk to your lawyer about it, please.
Okay, I'm sorry. Okay.
You're fine. Okay. Yeah, that's
I really don't want my son.
All right. On the possession of meth, bond's 5,000, the paraphernalia is 1,000, the tampering or destroying evidence is 5,000. Court date's gonna be September the 14th at 9 o'clock with random UAs. So we'll find out, won't we?
Yes, sir.
Step to your
Good
right
luck.
to the T. Sir, Ms. Busa is medically unable to come.
All right, on Ms. Busa, she qualifies for a public defender. I'm gonna appoint a public defender to represent her. Her bond is 5,000 the heroin, 1,000 the paraphernalia with random UAs. Court date is September the 28th at 9 o'clock.
Yes, sir. State your name, ma'am.
Megan Michelle Anderson.
Ms. Anderson, you're fully court for criminal mischief. You understand that charge, ma'am?
Yes, sir.
I understand you've been given copies of paperwork and advised of your rights. Is that true?
Yes, sir.
All right, ma'am. You've indicated you're going to hire your own attorney or represent yourself. Is that how you're going to proceed?
I don't have an attorney right now.
Right.
If I can't get one, I'll just use a court appointed one.
Okay. Well, if you can't get one, you need to fill out the appropriate paperwork so we can qualify. If you do qualify, we'll be happy to appoint one for you. Okay.
Okay.
Deputy criminal history, Ms. Anderson.
It's out of Kansas, a domestic in 18, petty theft 17. That's it.
What brings you down here from Kansas?
I live in Florida now.
Oh, congratulations. Yeah.
My parents retired and they took me with them. I've been living here since 2017 or 18.
Awesome. Okay. Can you stay away from the other party of this?
Yeah. I'm sorry. Excuse me?
Can you stay away from the other party? Can you stay away from Mr. Zarda?
Sure.
Okay. I'm going to release you on pretrial release. You need to report to the pretrial release office before 9 o'clock Monday. No contact directly, indirectly, or through a third party alleged victim. Your court date's going to be September the 18th at 9 o'clock. Good luck, ma'am.
Okay.
Step to your right to the T.
All right. Okay, well, your client isn't ready. He's not ready.
He's connected.
No.
Oh, it was. I thought it was connected. Yeah.
All right, Mr. Love, I need you to get stationary. I need you to be seated in an upright position. I need you to be ready to attend court. I need you to stop rubbing on your face. I do.
I don't know. Mr. Love, you have to sit still and then you got to unmute.
Oh, hold on, counsel. No, don't do that.
Okay.
Hear me? No, the question is, can you hear us and why you're not ready for court? That's the greater question.
I'm sorry, I had work.
I'm sorry, I'm at work too, and I'm trying to do my work. And here's the funny thing. You have court, and I'm not going to hold court looking down your ear, nor am I going to hold court looking at your head.
I understand.
This is case number 23562. 7901, the people of the state of Michigan versus Mr. Love. Please state your full name for the court.
Bryant Love.
Mr. Love, why do you keep putting your ear up to the device?
Because it's like an echo. I can hear you though. I just want to make sure I'm hearing stuff.
Okay, well, if you can hear me, then stop putting your ear up because I'm not going to do it. Today is the date set for pretrial conference. How are we proceeding?
I'm going to set this matter for a bench trial.
I don't think I'm gonna be able to take a waiver from your client today. But
Well, I'm just set up for a jury trial, I guess.
we'll see if he can hear me.
I can't hear you.
Mr. Love, I can't. You have to come in person. I can't do it. I can't. Sir, I cannot have court. I cannot.
Yeah, I know. I don't know about it, man. I'm just gonna see.
Sir, I don't want to see the room that you're in. I don't. But I'm going to adjourn the matter so you can come in person.
Okay.
Mr. Flanagan, how many do I have on August the 30th? Oh, did you just, no, that was, how many do I have on August 30th? For us? Okay, Mr. Michael Davis, you're supposed to be in court right now. And it looks to me like you're in a vehicle. It looks like you're the driver of the vehicle. It looks like the vehicle is moving. That's unacceptable. Okay, look like you just got out the vehicle. You jumped out the vehicle. Now I need you to be somewhere stationary. I need you to get stationary, Mr. Davis, because we're all in court and we're waiting for you. We are waiting for you. And I don't like to wait, Mr. Davis. They told me when they gave me this job that the people were going to wait for me. They didn't even tell me that, Mr. Applebaum.
Judge, 40 years I've been trying to wait. Hitting my 40-year anniversary soon.
Is it? Mine. I'm on 32. Coming up on 32.
And I don't want to win that race.
No. All right. Looks like your client might be ready, but his device is just doing a lot of stuff. It's flip-flopping. It's doing a lot of stuff. And I don't really like it. I don't even like the way he's standing up, leaning in.
Oh man, what? Okay.
Don't
Find a
tell me-
chair.
don't
Mike,
let-
find a
don't-
chair.
don't-
Find a nice, comfortable chair and sit down in front of the
Don't
camera.
tell me, oh man, you the one trying to come to court doing whatever you doing. I'm in court. I'm sitting in my chair.
Okay.
You the one not sitting in your chair. You the one think I'm supposed to wait on all of this. You the one got too comfortable with the fact that we on Zoom. That's what happened right here. Then you're gonna say, oh man, like I'm supposed to just sit up and let the people lean in like that. Good morning, Mr. Basant. Now he moving. Do y'all know I'm getting ready to cancel Zoom court? I'm gonna cancel.
Don't do that to me, Judge. I live
Okay,
in Florida.
well, I mean, the people, they don't know how to come on here and be correct.
I'm sorry, Judge. I'm across the street at Frank Murphy, Judge, but
I'm gonna cancel it. I promise you. Now it's gonna be a struggle for me because that means I'm gonna have to get up every day and go down to court and be in person. But I think it's gonna work out for me.
I'm 6 months a year, Judge. Don't do it to me.
You say you only here 6 months a year. You
I live in
snowbird,
Florida the other 6 months when the snow starts hitting.
Mr. Applebaum. I want to do that so badly. They won't let me. All right, Mr. Basant, you are here for Ronisha Williams, correct?
that's correct. Yes, Judge.
All right. And Mr. Basant, you went in the hall in the stairwell or something. You got real dark. I am getting ready.
I'm in the stairwell.
Well, I'm getting ready to do a sentencing, and then you're next. So I'm going to handle Mr. Applebaum's case first. Okay.
Thank you.
You're welcome. All right, this is case number 23. Let me share my screen. All right, this is case number 23-554-6801, the people of the state of Michigan versus Michael Anthony Davis. The defendant is charged with one count
of malicious destruction of property. Today is the date set for sentencing. Appearances, please.
Good morning, Your Honor. Alan Applebaum appearing on behalf of the defendant.
And Michael A. Davis.
Ms. Ritter, what happened to Ms. Ritter?
Right here, Judge. For the record, Your Honor, Christina Ritter on behalf of the people.
All right, and then Mr. Davis, your name, please.
Michael A. Davis.
Sir, what does the A stand for?
Anthony.
Thank you. Today is the day set for sentencing. The court has had an opportunity to review the pre-sentence report. With respect to the report, are there any additions, deletions, or corrections on behalf of the people?
None on behalf of the people, Judge.
On behalf of the defense?
Your Honor, my client indicates that on his criminal history, the 2 misdemeanors have been expunged. I don't have any paperwork on that, but he indicates that those 2 have been expunged. In addition, Your Honor, this case has, at least as far as my client is concerned, a little tortured history. But on the pre-sentence report, under the evaluation and plan, it indicates that the plea agreement in this case indicates that the defendant pay full restitution for a term of probation set by the court. Again, the court recalls that my client originally indicated that in the plea document, when the plea was taken, and we have the transcript, I know the court has the transcript, there was no indication of a term of probation. Obviously, my client was under the impression at the time, because we've had this discussion twice now, that he was going to simply pay the restitution and the matter would be resolved, I guess, if that's the right word. So the court has indicated that the court is the one that's going to make that decision, not the prior judge that took the plea. But I just wanted the court to refresh the court's recollection on that. And so it was, at least in terms of the plan, at least on the record, I don't think there was a language regarding probation, but I understand the court's inclination because we've had more than one conversation on the record on that. And once we get past that, Your Honor, I'll elocute on behalf of my client for a minute or 2.
Right. With respect to sentencing, is there anything on behalf of the people?
Judge, as far as sentencing, the people just asked the court to adopt the plea agreement made in this matter.
Well, do you disagree with Mr. Applebaum that the plea agreement included a term of probation? That Mr. Applebaum says that your plea agreement did not include a term of probation?
The people do disagree on that standpoint, Judge. I believe that the plea agreement did include a term of probation, from my understanding.
And then Mr. Applebaum asked the sentencing.
All right, Judge, again, I have a copy of the transcript when the plea was taken, and basically the judge said the court's going to accept the plea. The matter is going to be referred to the probation department for a pre-sentence investigation report. And you're going to come back for sentencing, and that's going to be in front of Judge Bryant. That's the sum and substance of the quote unquote agreement. So I don't think on the record, that's the right word, there was any claim that there'd be a term of probation. But again, Judge, you and I have had at least 2 conversations regarding that issue, that you have the authority to issue a sentence that you believe is appropriate in your sole discretion. And I agree with that, and my client agrees with that. But I do want the record to absolutely reflect that at the time this plea was taken, my client was under the impression that it would be restitution only. He stated that on the record in front of the judge that took the plea. He's taken that stance in front of you on 2 occasions, and the transcript again is silent regarding that. So be that as it may, Your Honor, my client he's a businessman. He was a little, if you read even his version of the report, he was a little frustrated at the time of the incident because they were the alarm company was overcharging him. He did admit that he damaged the unit, and that's why we're here today. But also in reading the report, Your Honor, it looks like the victim only, I would take the position that the victim only wanted restitution. The victim didn't make any statements. The victim didn't proffer any additional punishment that it wished upon this defendant. And so again, we'll leave that in the court's discretion. I would say, Judge, that at the time this incident happened, my client's the mother of two of his younger children, his two youngest children, had recently passed away. I'm not sure that's an excuse to do the actions that he did on that date, but he's the father of four young children. He's got sole responsibility, financial, emotional, for all four of those children, because the mother did pass away. I'm not sure the word remorseful is the right word. The court's had in front of you a couple of times, but in private, I think he's just maybe frustrated at how this matter came down. Maybe that's part and parcel of his quote unquote. You're reading the anger in his language, that I think it's more of a frustration than anything else. But he did take a plea. He's taking responsibility for that action. I do more of his civil stuff. I don't do. Oh, I do also want to say that he has, in page 1, they're showing some matters in Novi. I'm, as an officer of the court, all the Novi matters have been dismissed. He has no pending criminal matters in Novi, that's for sure. I can say that as an officer of the court. And I'm hoping that Mr. Davis can elocute to the court some remorse and what's going on in his life. But again, he was under the impression, right or wrong, that he would pay the restitution, the matter would be taken care of. And if the court's going to impose any probationary sentence, I would ask it be fairly short term. I don't know, non-reporting if it's possible, because I think that's what everybody thought was going to happen. And I'll keep quiet while I'm ahead, Your Honor.
And would Mr. Davis like to address the court as to sentencing?
Yes. I deeply apologize on the things and matters that I did on that day and took place. I was in a vulnerable point in my life, even though that's not an excuse. And, I was frustrated that this scaffolding company had overcharged my credit card $8,000 and the bank wouldn't remove it. And when I went up there, the staff members surrounded me, and that's why I just bagged my way up out the hallway, fast and best way I could. And sliding the time clock off the desk was in the way of me getting out of there. So I do apologize for ruining their time clock and the paint on the wall, and that's why I wanted to pay for it. And just whatever consequences come from that, I have to accept it.
All right, the court has had an opportunity to review the pre-sentence report. And of course, you are correct. We have discussed what the understanding was supposed to be, but I'm going to share my screen, because this morning you said that your client didn't even think he was supposed to go on probation. And I'm going to share my screen. And on my screen is the plea agreement between Michael Davis and the people of the state of Michigan, where he pled guilty to 1 count of malicious destruction of property. And it says, number 2, defendant also agrees to pay full restitution amount of $1,227.63 for a term of probation set by the court. That's what it says. That's the plea agreement. And then you come down here, it is signed in a space that says defendant's signature, a space that says prosecutor signature, and a space that says defendant's attorney signature. All 3 spaces are signed. So it continues to boggle my mind. And then the transcript is clear that Judge King additionally said, I cannot tell you what Judge Bryant is going to do. So it continues to just baffle me that we continue to come here and say there was nobody thought he was going on probation. Yes, he knew that he was going on probation. Now, he may have chosen not to hear it or receive it. He signed a paper saying he was going on probation. The judge said, I can't tell you what Judge Bryant is going to do in terms of the probation. And then every time he comes on here, every single solitary time he come on here, you say he expresses frustration. You call it a potato and I call it a potato. A tomato. Frustration, anger, frustration. I mean, I asked him to stand up this morning. He got a problem with standing up for court. I'm talking about for court. He got a problem standing up for court. He want me to have court with him leaning down like he at some casual function. This is court. This is court. And there is a certain level of respect that comes to coming to court. I know people so casual nowadays. They almost probably want to call me Lanice. They probably don't even want to have to say judge. Well, it's not going to happen. I'm old school. That's what they want to say. I'm old school. Been doing this for 32 years. Been on the bench for 16 of those 32. I've seen people come with contriteness and remorse. I've seen people come who don't care one iota. I've seen people come who are angry and people who are not angry. From day one, I've done nothing to Mr. Davis except preside over her cases. That's all I've done. All right, so we're gonna get to it because what I don't allow and try not to facilitate is denial. That's the paper that is signed by 2 attorneys and the person who signed on the defendant's line. And it clearly said he was going on probation. He was agreeing to go on probation. Okay, court is going to accept the recommendation of the probation department because, that's too much. Court is going to accept the recommendation of the probation department. I'm going to sentence Mr. Davis to a term of probation for 12 months. And that places a final review date of August the 23rd, 2024. However, Mr. Davis, of course, will be eligible for early discharge after 6 months. Court will set another review date for February the 23rd. At 10:00 a.m. If you have completed the terms and conditions of the probation by that time, then you are eligible for the early discharge. And additionally, notwithstanding the fact that Mr. Davis has been rude to the court, Mr. Davis has been disrespectful to the court, Mr. Davis has, I don't know, shown the court that perhaps he doesn't necessarily fully pay attention to what is being said or done while in court, which is the very reason we have transcripts. I am going to afford Mr. Davis. Okay, y'all, hold on, y'all. It's too many chats coming up. I'm going to afford Mr. Davis the benefit of a delayed sentence. Look at that. Look at. Okay, nobody even asked me for the delayed sentence because he was so focused on he was going to be on probation. But I'm going to, on my own, afford Mr. Davis the benefit of a delayed sentence. Okay. That means that at the conclusion of the probationary period, if Mr. Davis successfully completes the terms and conditions of his probation, then this conviction will be set aside. The case will be dismissed with prejudice and the conviction will be removed from his record. The terms and conditions of his probation are as follows. You shall not violate any criminal law of any governmental unit. You must not leave the state without consent of the court. I am going to make this a non-reporting probation. However, Mr. Davis must be responsible for completing the terms and
January
conditions
6th
of his
of 23,
probation
and
without the excuse of nobody reminded me, nobody told me, nobody said nothing, because nobody is saying nothing. I'm saying it right now, and we're going to mail a copy of the report, of the court's order. It's going to have the phone number for the agency that he's going to call for the classes, and nobody is going to remind him because he's not going to be reporting. All right, you're going to pay $210 mandatory costs. There was an agreement for restitution in the amount of $1,227.63. Additionally, the court is going to impose a $200 fine. This is non-reporting, so there are no supervision fees. There is a $35 assessment fee. The total fines, costs, and fees, not including the cost of any classes, is oops. Oh, wait a minute. I messed up. Okay. $1,672.63. And you have the duration of probation to pay that amount. However, in order to be discharged early, the amount has to be paid in full. You shall not use or possess any illegal substance. You shall not drive without a valid driver's license. According to this report, Mr. Davis's license is valid. You shall pay any outstanding tickets that you have with 35th District Court. According to the report, he has none. You shall attend anger management 12 weeks of anger management through eVay. We will send the number in the paperwork. You shall have no contact with the complaining witness, which is Scaffolding Incorporated. And we will return to court on February 23rd at 10 o'clock. We will mail a copy of the court's order to the Terry Street address. And if needed, we will contact you at the phone number ending in 1556. Is there anything further with respect to Mr. Davis?
Two things. I have a copy that, oh, I'm sorry, ma'am, go ahead.
Not from the people, Judge, thank you.
I have two questions, Your Honor. Can I have a copy of the order mailed to my office in Northwestern Highway?
We can email it to you.
Same thing, that's good enough.
All right.
I got the last email from your clerk, so I know it works.
All right, great. Then, Mr. Flanagan, once I do the order, can you email a copy to Mr. Applebaum?
Yes, Your Honor.
All right.
And last but not least, Your Honor, my client, I just want to make sure my client travels out of the state on business. And so I just need, will there be information in his package of who he should contact in order to get permission to travel out of state for business if it's necessary?
I'll allow it. I'll give permission right now.
Thank you.
Anything further?
No, Your Honor.
All right. Mr. Flanagan, you can put in the order that he can travel for business.
Okay.
All right, then we're all set. Everyone have a great day and stay safe.
Thank you, Your Honor.
Thank you, Your Honor.